Hello, everyone. Welcome, welcome, welcome. We're so excited to have you here. Oh, look at all those lovely people here. Thank you so much for joining us. We love to have your cameras on because we like to see your smiling faces or whatever else you're doing. We have this lovely lady, Norma, coming on today, and I thought she's such a contribution. If you have ever met her in person, she's just this wonderful lady. And I thought, oh, well, here's a nice little quote. No act of kindness, no matter how small, is ever wasted. And I just thought that was so appropriate for Norma. She's just such a generous lady. So today we have Norma Williams with us. She's an attorney. She works in the real estate world of negotiations, putting deals together, making sure they close, making sure everybody's got what they need to have a really good experience. So Norma, thank you so very much for coming. I'm so happy that we met at the core meeting and that you are here today. So welcome, welcome, welcome. Take it away.
Thank you. So as Peggy mentioned, I'm going to be talking about the role of an attorney in commercial real estate transactions. And in general, there are three roles that an attorney can play. First is transactional. We are basically doing the contract formation. The second is litigation, where your disputes come up and you're resolving those. And third is regulatory, which comes up in the context of some of the transactions where there's some type of governmental oversight, for example, with some of the multifamily lending programs, et cetera. So my role is purely transactional contract formation. And so this presentation is probably going to be most appropriate for direct property purchases as opposed to passive investments. So it's when you actually go in and buy a property. But my understanding is that I'm sure some of you will also do that. And so it would also be significant, for example, for nest egg building when they're buying the assets that you all end up investing in. So first, I was going to talk about what I do as a transactional attorney and what I don't do. So the first thing that I do is, the transactional documentation itself, and I'll describe a little bit more about that later. And I work with all the commercial real estate asset classes, so office, industrial, retail, multifamily, hospitality, entertainment, and others. My services generally, and not just my, but other transactional attorneys, our services generally begin after the letter of intent is drafted, though in a lot of cases I would like to have input before, but generally my services start after the LOI is drafted, and my services end at the closing. So when I'm representing the buyer, I'm not involved with ownership issues, with property management. When I'm representing when I represent lenders, I'm not involved with loan administration. I may have a separate engagement for that later, but my core transactional representation just involves doing the deal. So in addition to purchase and sale, I also do commercial financing and leasing transactions. I might be on either side, though, in financing. I'm more generally on the lender side. So what I don't do, I don't find properties, and those of you who are sophisticated know this. I mean, that's a broker's role. I don't do litigation, as I said. I don't work on single-family residential or other residential transactions. I mean, I do work on multifamily, but that is a commercial real estate asset class. I don't locate or arrange financing. I mean, these are the things that people ask me about. And I don't work on out-of-state transactions unless a local attorney is involved at state or other as required. So each of the states have their own rules about, what attorneys who are not licensed in that state can do. They vary. Some you have to associate a local counsel. Some it's okay if you do the same transactions for the same client in your own state. But basically, if the property's out of state, I have to figure out what I have to do in order to practice in that state. So the documents I mentioned that I prepare contracts, I review contracts, and I specifically say reviewed, drafted, or reviewed because I may be drafting them or I may be reviewing what someone else presented. So what are those documents? First, as I mentioned, is the letter of intent, if I get involved in that. Second is the purchase and sale agreement itself. Third is the escrow agreement if it's not part of the purchase and sale agreement. Fourth, which is very important, are all the ancillary documents that are to be executed at the closing. So the bill of sale, the assignments, the terminations, et cetera. And those are usually exhibits to the purchase and sale agreement. And then once I've negotiated and documented or reviewed and been involved in documenting the purchase agreement, then the next stage would be for me to review all of the due diligence material, the environmental, leases, title, survey, physical inspection, if that's necessary, seller disclosures. And I think, here's where, and you'll see in some of the examples that I mentioned, an attorney performs a valuable role. Other documents are the loan documents, whether I'm representing the borrower or the lender, closing instructions to escrow and title, and also a closing checklist if it's a complicated transaction. So if it's a large transaction where there are multiple parties, many people doing many different things, it's customary to prepare a closing checklist of what has to be done, who's doing it, the status, and when it's completed, so that you're not saying, oh, did so-and-so, send their title comments or whatever. And usually, sometimes that can be delegated to a more junior attorney or to a paralegal, but basically there has to be attorney oversight over a closing checklist in a very complex transaction. So I wanted to talk about three misconceptions about the role of the attorney in commercial real estate transactions. And, in that, talk also about what I do. And with all these misconceptions, and I'll just tell you what they are. First is that a broker can do it. So what's your role? The second is that there are form documents for everything. So what is your purpose? And the third is that lawyers are expensive. So with all of these, it's common misconceptions. I want to do kind of a cost benefit analysis, or mention that there is a cost benefit analysis in each of these. And so, when I talk about what a broker can and can't do in a given situation, your budget for legal may be X or Y, but in each of these, you just have to do a cost benefit analysis. So the first, as I mentioned, is that the broker can do it. And so, first, to differentiate the broker role, I would say brokers locate properties. They prepare the letter of intent, setting forth the major terms of the transaction. They interface with the escrow company and the title company on scheduling and changes to transaction milestones. They don't give legal advice, or often, I can't identify what requires legal advice. And I have great respect for brokers. I couldn't find 5 properties in 2 different communities that are suitable for a prospective purchaser, as a broker could, but on the other hand, they're not lawyers. So I wanted to mention a couple of transactions that I was involved in where this distinction mattered, where basically the parties relied on brokers. And, I, as a lawyer, came along and I think added, contributed great value to the transaction. So in the first transaction, I was representing the the sellers of a substantial real estate asset. And prior to coming to me, they had executed a purchase and sale agreement. And in that purchase and sale agreement, they had agreed to provide seller financing for pretty much the entire transaction, for the entire purchase. And one thing, so I got the PSA, the purchase and sale agreement, I got the seller financing addendum, but in the documents, there was no guarantee. And so in California, if there's seller financing and the borrower later defaults, there's a foreclosure sale, and say the sale doesn't produce enough, a large enough sale price to pay off what's owed to the lender seller, then the seller cannot get a deficiency judgment, meaning they can't get the difference between what they were owed and what the sale price and the sale price. And so that's very significant, and it's unique to seller financing. With other kinds of lenders, it may depend on the kind of foreclosure. And so it was important. So in these transactions, it's very important that there be a guarantee, because there has to be some financial backing so that the seller lender can recoup that deficiency. And so, it's kind of frustrating to get this, but, I was able to find something to hang my hat on in the seller financing addendum. And what it said was that the buyer would guarantee the loan. And so I said, that's helpful. There's a guarantee in there. But the issue with that legally is that there's no separate liability. By saying that the buyer would guarantee the loan, that doesn't add a third party. It's basically saying that the buyer who already has an obligation under the loan is also the guarantor. And that's called a sham guarantee. There's no liability there. So it most often comes up, like, for example, with general partners, where in a general, if a general partnership is a borrower, if the general partner guarantees, that's called a sham guarantee because the general partner is already liable. And so fortunately, I was dealing with, a pretty scrupulous and honorable buyer who, said, well, yeah, who acknowledged that there was supposed to be a separate guarantee. And so, we were able to get a guarantee from a separate, highly solvent entity that wasn't, the alter ego of the borrower. But in that case, they just, the broker and the seller just didn't know about the fact that they couldn't get the deficiency judgment, and that that having a borrower guarantee its own loan just doesn't add any liability. I mean,
Matt has a question in here. Is it okay if I ask you now?
Sure.
Or wait till you're finished?
Well, why don't we wait, because I'm already behind, if that's okay. And then another transaction in which an issue came up, broker only involved again when they came to me only after the purchase agreement was signed, was a transaction in which they not only had signed the purchase agreement, but they were kind of into the transaction. They were doing physical inspection. They had gotten the title report. There was some due diligence going on. And so I said, well, did you get the title report? Yeah, how was fine. And I said, well, let me see it. And in looking at the title report, I noticed that one of the Schedule B exceptions was any community property interest of the spouse of one of the individual sellers if he was a married man when he acquired title on, such and such a date in such and such a document. And, it's like, this has to be, if this isn't cleared up, I mean, basically my client is not going to get good title. And so I think the issue here is that a lot of documents that come in are perceived by parties and, brokers possibly as it's just another document that came in that we have to review. But there's significant, legal liability. And with title reports in general, a lot of times people think that, there's nothing you can do about the Schedule B, or little you can do. I mean, if there's an easement, there's an easement. What are you going to do about it? If there's, but there are a lot of things. I mean, there's CC&Rs, and they often think that a title report just tells you who owns. But the thing that was egregious about this was that this did actually go to a title defect, but it was just kind of thrown on the stack. The last example that I wanted to mention was a situation where, again, they came to me after, and the parties had agreed in the LOI for like a 60-day due diligence period, but and I represented the buyer, and when the seller's broker prepared the documentation, they put in 30 days, and so the transaction came to me, and I feel like for a month all I was trying to do was get extensions. But the point was, I went to the seller and said, well, why does this say 30 when the LOI is at 60? It's like, oh yeah, we know, but we just put in 30 because we want to make sure they go forward on they get started on ordering the physical inspection, which is pretty unscrupulous on the part of the seller's broker, and it's pretty negligent on the part of the buyer's broker not to notice that. But the point is, it happens. And so the other thing in this transaction was that they were getting financing from a government source that had a long lead time. And yet all the due diligence, and once that lender was in place, they were going to do all the same thing. They were going to review environmental, they were going to review title. But the way the purchase agreement had been prepared, my client had to do all that. I had to do all of that before the lender even came in. And so it's really important to structure things properly. So the next misconception that I wanted to address was the use of form documents. And a lot of people, as I said, say, there are all these form documents. Why do we need you? And so, and there are a lot of form documents. I mean, the AIREA, the American Industrial Real Estate Association, has very comprehensive forms. They have a standard form for non-residential purchase transactions. They have a standard form for vacant land. They have a standard form for properties with more than 5 residential units. They also have many lease forms. State trade associations of brokers, for example, the California Association of Realtors, they put out form documents. Bar associations have documents. If you go on the web, you can get a form of a document. And, who knows, there may be AI generated forms to come. And so what's wrong? What are the issues with standards forms? Well, for one thing, many of them are incomplete. So if you get something off the web, it's not going to address everything. Some of the ones that are more comprehensive likely address all the major issues, but they may not be addressed to the satisfaction of the parties or with the requisite detail. And a lot of the form documents, the fallback positions, that is, if you don't do something, then this will result, may not be favorable to one of the parties. I'll talk about that a little bit more. And then a lot of them fail to address unique state laws. I mean, obviously, CAR is going to address California law, but if you pick up an AIREA form, it may or may not address California law. And so anyway, so some examples of issues with standard forms that, I've run across in the AIREA purchase agreement, it has a provision for the buyer default, which is that, the earnest money deposit is retained by the seller as liquidated damages, but there aren't any provisions for seller default. And so, so if you specifically, you're kind of left with state law, and maybe there are remedies, but some remedies you may want to specifically say, that the buyer can bring an action for specific performance to compel the seller to sell. You may want to say that, damages are allowed. You may want to say that consequential damages, not just what I lost, but the fact that I, couldn't lease to the company I leased. And so you need to have a remedy for seller default as well. The other is what I talked about of the fallback position. So, for example, in the AIREA form, there's a default provision that there's a contingency that the buyer has to notify the seller, I finished reviewing the physical condition and I'm satisfied or I'm not satisfied. So there's a default provision that if the buyer doesn't say anything, it's conclusively presumed that the contingency has been satisfied. In other words, that the physical inspection, the buyer's fine with it. It has the same presumption, conclusive presumption with regard to the financing contingency. So, if the sale is conditional on the buyer getting financing, but they don't tell the lender that they did or didn't, then the fallback position in this standard form is that the loan has been obtained, which basically means the buyer has to close whether or not they have financing. So you don't necessarily want that. You may want to change it to what's called active approval.
Yep.
But another problem in standard forms is that there are numerous pro-broker provisions that really don't belong in a purchase and sale agreement. And so, for example, that the buyer is supposed to use the services of the buyer's broker for 1 year after the sale. And maybe that's good, maybe that's bad, but it shouldn't be in the purchase agreement. It should be in the listing agreement. There's an attorney's fees provision in the PSA that says that, the parties, if there's litigation, the prevailing party is entitled to its fees. And the form says the broker and the parties. And that's just kind of snuck in there. One that, I found to be troublesome, which didn't come up because of the provision in the purchase and sale transaction, but came up as a result of due diligence, is that I was representing a purchaser and there were tenants on the property. And one of the leases said that if the landlord, one of the tenants exercised an option to, extend their lease, that the landlord had to pay the original broker a commission on that option. So if they exercised for 3 more years and the rent was X, the broker had to be paid, a percentage of that as a commission. And so my client, and it also said that provision was binding on any subsequent buyer, any subsequent owner. And so my client who was buying kind of looked at it and said, I don't want to do that. I don't want to pay a commission to this broker if, this tenant that in this building exercises the option. And so, I said, okay, we told the seller to go to the broker and say, would you waive this? And they said, the heck with you, we're not waiving a commission, prospective commission. And so we said, okay, fine, but what is it? I mean, we know what the total option consider rent is the rent's going to be, but what's your commission? What's, you get 2% of that, 3%, we don't know, what's your, and so then they said, well, we did all the deals for the landlord and we don't really have a written listing agreement, but it's generally 3% for, and so, but the law is in California, and I think most places, that an agreement with any broker agreement for commission has to be in writing, period, end of story. There's no exception. And so we just got rid of it. But, so here, this kind of shows you additionally the importance of your due diligence review. Another issue in the standard forms is a incomplete or missing treatment of state law issues. I mentioned that, but for example, in a form it may say the parties waive trial by jury. Great, not so great, but in California that's totally unenforceable unless that same contract has the provision for an alternative way of resolving disputes. So it has to say judicial reference, it has to say arbitration, it has to have something. And so again, that's important, something that an attorney would know. And then I had down here, as is provisions, which parties may not want, representations and warranties, how long representations and warranties survive, whether there's, if there's a breach of a representation, that turns out the seller, there's some litigation, like what, is there a maximum or a minimum? They call baskets and caps, but these are just things where a transaction has to be tailored, and this stuff is just not addressed in form documents. So the last misconception is that lawyers are expensive, and and again, the cost benefit analysis here is that, consider that the cost of using an attorney may often be more than recouped by the avoidance of errors in transactions. And so a lot of the things that, I mentioned having to do, due diligence before, all of the things that I mentioned, I mean, you can see where the clients had to pay significantly, whereas if things had just been done correctly, I say to us, please see me before you sign anything. It would have been, saving for the client. And so I did want to mention, though, some, ways to save costs on attorneys' fees. The first is the fee structure. And so, most attorneys' fee structure is hourly, and that's because generally you can't predict what's going to happen. I mean, I will often tell a client, they'll send me a lease, they'll send me a purchase agreement. I'll often tell them, okay, it'll take me 2 to 3 hours to review this. I mean, I can say that because I just know what it's going to take. And, but what I have no control over is whether when the tenant, lender, whoever sends it back, it's not going to be like, drowning in red ink because they changed everything, or it's not. And so it's only fair to me that, I don't know what title is going to look like. So I don't know how much time I'm going to spend on title. And so for that reason, most attorneys will have an hourly rate structure. In some cases, it's kind of rare, but in some cases, the fee structure can be a flat fee, but that has to be if it can be predicted, if the full scope of the representation is predictable. And so, have that discussion. So a fee structure, a flat fee or a hourly fee, but up to a cap, might be a fee structure that would be beneficial, and save costs. Another thing that's really important is estimates. I mean, get estimates from attorneys. I mean, even though I don't know what's going to happen in every transaction, I know that, when I look back over all the transactions that I've done, the total attorney's fees have come in within a range. I mean, I just know that, and so, I'll put caveats, I'll say, but I don't know, and it's just an estimate, all that in my engagement letter, but try to get estimates. It's kind of hard to, push back from an estimate, without having to justify it anyway. The next thing in terms of savings is that I called it the attorney starting point. And I mean, you should know, and most attorneys, be obvious. I mean, nobody who's experienced is starting with a blank piece of paper. I mean, everybody, and I represent institutional clients, and a bank has their form of loan documents. They have their form of selling REO. And so, that, it would be hard for an attorney to represent they were starting from scratch, but just know that, I guess I'd say. You can also limit the scope of review, where you say, I can do such and such in-house. I don't need you to do this, or I just need you to do this, or I've done this type of transaction before, but so just, up until that. And so, the engagement letter, the, attorney will go all out of their way to like make sure that's very clear. So they're not, held liable for doing more, but you can certainly limit the scope of review. The next thing is just develop your own forms, which may or may not be cost effective if, you don't do a lot of transactions, but related to that, which I've seen a lot of clients do, is develop their standard addendum to form documents. And so if you know that in the AIRE form, the thing that just like drives you crazy that you just is non-negotiable for you is, active versus passive method of approving. Like you always have to have a provision in there that, if I don't tell you I got financing, then I didn't get financing. But you always have to, or your preferred method of alternative dispute resolution is judicial reference. You hate arbitration or whatever it is. Just have like a standard, 5, 6, 7, whatever it is, number of pages where if someone hands you an AIRE form, you just say, here's my addendum. And so you're at least starting from there, but you're not looking at each transaction. So anyway, that is my presentation. So I will ask if there are any questions.
There are. Well, we know Matt has one. If you put your hand up by using the hand at the bottom under reactions would be really good for everybody. So go ahead, Matt, ask your question.
Great. Hi, Norma. Yes, I've done a lot of these over the years. We do them for clients, but I had a question because often the ones that I look at are non-consumer, typically commercial properties where there's multiple tenants. There's a whole variety of topics that need to be covered on these financing deals. And
what do you mean by financing deals? Seller financing or what do you
seller
mean?
financing, yeah.
Okay. Uh-huh.
Yeah. And even though, the real estate groups out there have these forms, it just never seems like enough, right? But I had one question for you. So you opened up with the question relating to a deficiency judgment, right? But as it may pertain to a buyer of a residential property they're using as their owner-occupied residence, and as it relates to the qualifications under Frank Dodd, who's responsible for that?
So I will say that I do not do residential transactions.
Okay.
And in a lot of ways, people think, oh, it's residential as opposed to, buying the Bonaventure Hotel or something. But it's harder because it is so highly regulated. I mean, there's a whole body of laws in the civil code that only apply to transactions involving residential 1 to 4. And they address, disclosures. I don't know consumer law, so I can't necessarily answer that. I mean, I can't answer that. I just do commercial.
Well, I could answer that.
Oh, good.
It's different on the single family owner occupied. The lender only gets the property back. There's not a guarantee of like that deficiency. If there's a deficiency, somebody eats it. They can't come after you for more unless you have done a refinance. So if it's a purchase agreement, they only get the property. If you've done a refinance, well, that's totally different. Then they could come after you for some other things because you possibly have pulled all the equity out of the property when the property was high and now we're in a low. I've never seen a resident ever gone after for that when they pulled the money, but I know that they could do it if they did a refinance, but not on a purchase agreement. That's just for consumer owner occupied.
Thank you.
And anti-deficiency laws are incredible in California. I won't even go into it because I think most of you are not from California, but the form of foreclosure matters. It's a whole body of law and whether guarantors are anyway, just you don't want to hear about it. I mentioned seller financing just because we're talking about purchase and sale transactions.
Yeah, so that was really interesting that they said that the buyer was guaranteeing the loan. but there wasn't any deficiency set, or could you
Well,
go back over that again?
Yeah, because the seller cannot get a deficiency in a transaction in which there's seller financing, the seller also wants there to be a guarantee, right? They want
Right.
somebody that they can go after for the difference between, what they were owed and what the property sold for. That's called a deficiency. And in California, you just cannot go after the buyer. And so you need a guarantor. And so guarantee, by definition, means the obligation to answer for the obligation of another, the obligation to, parents co-sign a loan or whatever. There has to be a difference between the guarantor and the borrower. And if the borrower and the guarantor are the same person, then it doesn't meet the definition of guarantee, which is, you're satisfying the obligation of another. And so to say that the borrower will guarantee the loan is meaningless because the borrower was already liable. It's not of another. And so we had to bring in a different entity to be the guarantor.
So would that be like a key person?
It could be a key person. There was another entity who was affiliated, but was not the quote alter ego of the borrower. I mean, it was, separate assets, separate balance sheet, not the same ownership. It really was a third party guarantor. I mean, I guess if you had the concept, if you thought of, guarantor, if you just also said third party guarantor, which is really what a guarantor is,
Okay.
then that would make sense because it can't be the borrower. It's someone else.
Is that standard in commercial? That
Yeah,
it's guaranteed? The seller carryback is guaranteed?
it should be.
It should be, but I didn't ask that. Is it?
Yeah, if people know what they're doing. I mean, or else the seller is just, agreeing that they know that they're not going to get a deficiency. And that's, why would you let?
And that's built right into the purchase agreement.
Well, it's not in the purchase agreement. It would be in either, it would be in the purchase agreement. Yeah. It would be
Yeah, sure.
Yeah, I was going to say the seller financing addendum, but yeah, you would have to, one of the, well, actually, I'm sorry, it would be in the loan documentation. It would be in the purchase agreement, but it would also be in the loan documentation. So there would be a loan agreement, and there also has to be a guarantor. But yeah, it's part of the purchase transaction.
So going back to like the beginning, you told us about you got called in after.
Mm-hmm.
So ideally, what is the best time to call someone like you?
Mm-hmm.
Do you do it, let's just say somebody's doing a 1031, but they want to go find the right property. They're working with an agent. Is that the right time to like call you and say, look, this is something I'm going to do. Can you?
Yeah. And I don't have to, I mean, I don't want to draft the LOI. I shouldn't draft the LOI. I mean, any competent broker should be able to draft the LOI, but I'm saying the letter of intent, but I'm saying, show it to me before you sign it. I mean, I don't care if it says it's not binding, just show it to me before you sign it. But on the other hand, I mean, if people are pretty sophisticated, maybe I don't need to see the letter of intent, but ideally I would like to, come into transactions and just take a look at the letter of intent to tell, to say what might be missing. And in all cases, call me before you sign the purchase agreement.
Okay.
Yeah.
Great.
Mm-hmm.
So 1031 people are good people that are going out and looking for something. Do the accommodators by any chance refer out to like people like you, attorneys?
They probably do. Yeah, I haven't gotten a huge amount of business from accommodators, but that's a thought. Yeah, they're usually entitled. Yeah, that's a thought.
I mean, it seems like the most logical, but of course, always it all depends. But an agent who's selling the property for a seller would then be out looking for the next property if they're in this area, unless they're moving to another area and want to take their commercial out with them.
Yeah.
Yes, Ted.
Are there any AI tools in the process of development that, let's say, may level the playing field among attorneys in your field?
I don't know the answer to that in terms of what AI tools are out there, but what do you mean by level the playing field?
Well, presumably, let's say a generative AI tool would have the capacity of being able to read all the documents and identify what, let's say, what might be missing that attorneys are doing now.
Well, I mean, a form of and this is not transactional, but a form of AI has been, say, used in litigation where it might go through like a deposition transcript and find all the places where, you know, a certain term is used. I mean, I think that, I mean, in terms of transactional documents and AI, I mean, I think that it could see if certain issues are treated, but whether or not it's treated to the satisfaction of the parties, I don't know. I mean, I don't necessarily think so. I mean, that means that the AI document would have to do a legal analysis to see, you know,
That
whether
seems to be what's coming in the generative AI environment.
Yeah, it may be. I mean, and I'm pretty involved with, you know, very high level national real estate associations, American College of Real Estate Attorneys, American College of Mortgage Attorneys, and I haven't seen programs on that yet. And I think that, you know, they would probably be looking to that. But I just haven't heard it. I mean, I've heard, you know, of AI being used in connection with term papers and history, you know, looking up history and creative writing, but I haven't heard of it replacing, you know, legal analysis. But, you know.
Well, my
I
question would
suspect
be,
that AI can't do is to tell you whether let's say the parties like what they agreed to, but it should be able to tell us what they did agree to.
Oh, okay. Yeah. So in that sense, if you're saying, can AI like do a review of a document, like once it's been executed, say this is what was agreed to, maybe that's, you know, maybe that's possible because that's like, it's just kind of a reporting function. It's like a lease abstract almost. You know, what does the lease say about all of these terms as opposed to,
This
you
thing
know,
I've used attorneys for in the past is to look it over and say, and let's say to look over some, let's say, fine print document that I didn't really want to read that carefully, so they could summarize for me what the document said, and so that I could then decide, is that what I wanted or not?
Oh, okay. Yeah, I understand. I mean, maybe I misunderstood. I thought you were saying, could AI kind of perform the function that I've been describing that an attorney performs of reviewing a document for the benefit of a client? You know, if I'm representing a buyer and the seller sends me a form, you know, and I'm looking at it from the point of view of, does this help the buyer? I mean, is this what the buyer wants as to each of these, you know, 300 provisions or whatever? But I think what you're saying is once something is created, can AI summarize it? And I think that seems, you know, more doable.
yeah, because how would AI know if something's missing? Because
AI would have presumably been trained on the content that should have been there.
But there's no should in real estate. Every single transaction is different. There's no two transactions that are alike. It may seem like that.
The should would be what's in statute.
Yeah, but every buyer, you know, every buyer has different goals, and they have certain hot buttons that, you know, they may or may not want to address. And if they're buying a, you know, 100-unit building, they may have different goals. And if they're buying a 5-unit building, or, I mean, it's, I mean,
and the condition of the property, right? And then the disclosure thing, and then if the seller's not getting information to the buyers, and I mean, there's just a million different things that could happen. That's what makes real estate so interesting. That's why you all keep hanging around here.
Well, I would suspect that if an AI tool were trained on, let's say, 10,000 real estate transaction sets of documents, it might have a pretty good idea what should be
Might.
in them.
It might, somebody still has to review it to make sure everything gets dealt and handled. And I don't know if AI could tell you what's missing if it doesn't know what it's supposed to look for.
That's why I asked the question about what's in development.
No, yeah, I don't know that. I mean, I was
Yeah.
gonna say you could put AI through, I mean, you could, I think I heard once that, AI kind of knows the entire content of Wikipedia. And you could cut, maybe do something similar with law school, but, you'll hear a million lawyers say, we didn't learn how to practice law in law school. I mean, it kind of comes from, from practice. So anyway.
Eugene, thank you for attending today.
Thanks for the presentation. Do you do any work with the SEC?
No. Do you mean in terms of disclosure, investor disclosures type?
Yes,
work?
syndicates, syndications.
No, I work on, I mean, how I would be involved is that, a syndication might be put together. There's, lawyers, securities lawyers who work with the SEC in terms of, disclosures to the potential investors, the
EPA.
offering statement, et cetera. But where I would come involved is once that syndicate is formed and they've identified a property that they want to go out and buy, or they would come to me for that, and I would document that transaction.
And then
But
the
I'm not a securities
SEC
attorney.
attorney would put the other stuff together.
Yeah, a securities attorney would do that.
But that information would have to be in, wouldn't it need to be in the like the LOI or the purchase agreement?
Well,
If
you'd want
a
to,
syndication and a 506B or A or C.
well, I mean, you'd want a representation in the LOI and in the purchase agreement that the entity was validly formed.
Mm,
Um,
nice and simple.
yeah, that's what it comes down to at my level.
Eugene, anything else? Did that answer your question?
That answers the question. The only other question, so you're, okay, I think I know the answer, but so you're licensed in California?
Yes.
Okay, any other states or just California?
I'm only licensed in California. And so, as I mentioned, I cannot do transactions in other states unless I comply with that state's laws as to who can practice there. It's called unauthorized practice of law. And so that might require that, another attorney a local attorney be involved. It may be that it's okay as long as I'm doing the same type of transactions for the same client in my own state. One kind of classic example of unauthorized practice of law statutes is like in-house counsel, like an attorney for Bank of America, an attorney does it generally. They don't have to be barred, even if they are, in San Francisco, they can just have Illinois bar because they're called registered in-house counsel. But anyway, so it's a very elaborate statute. But bottom line, I would either associate somebody or just out and out refer it to somebody. If it's just something that, there's some things that, I can do anywhere, but I can't do it because, I don't know the local laws. I mean, if I look at a lease, from Connecticut, I don't know that they may have, some unusual remedies. So I can only practice in California unless I'm in,
Okay, and I've been able to get a deal done in California, but I almost had a deal done there once.
Mhm.
Then I found out it was on Indian land, and
Oh,
the deal,
oh my God.
yeah, the deal fell apart just because of, yeah.
That wasn't in the listing?
No,
That
no,
has to be in the listing.
it wasn't. This was 10 years ago. It wasn't in the listing.
So
Yeah, that's a whole
loser
nother body of
fight.
law. There's
Yeah, it was a
sovereign
whole,
nations.
I learned a whole new thing about dealing with the tribe. So,
Mhm, mhm.
yeah.
Yeah,
Mm.
it's-
Anyway, thank you.
You're welcome.
That it? Anybody else have any other questions? just always curious about that. I had written a whole bunch of words down. Oh, you talked about a bill of sale.
Mhm.
The bill of sale, that would be on a business side, right? For inventory and,
Well, oftentimes when real property is sold, there's also personal property that's being sold. So for example, and things that aren't
Like
fixtures, so things that,
pole equipment.
yeah, just, so it's basically, it's personal property. It's property that's being sold, but not the real estate itself. And so the way that title is transferred to that is through the bill of sale. And so there'll be usually be a bill of sale exhibit to the purchase and sale agreement.
Is that usually in addition to whatever the price on the property is, or is
No.
that included, or is that
No.
spelled out separately?
You know, accountant, that's an interesting question, because accountants will probably do that analysis for tax purposes. They'll see a gross purchase price and they'll end up allocating some of it to the land, some of it to the improvement, some of it to the personal property, but I don't get involved in that. But for purposes of what I do, there is one purchase price that applies to you know, everything that's being sold.
Because cost segregation, that's what it's called.
Mhm.
So do you have, so something like the umbrellas and all of that, even though
Mhm.
it's personal property, it's still going to have a depreciation schedule because it has to be supplied and then replaced.
Right.
Do you make suggestions about cost seg, or is there
No.
any involvement?
Mhm.
Do you tell
No.
people they ought to do it, or do you
Sometimes.
talk to them about it at all and how it makes a difference for, and should they
Sometimes.
talk to their CPA and that kind of thing?
Yeah, I mean, I recommend that people involve their CPAs. I think that, yeah, but I don't get involved in the cost segregation analysis.
Yeah, no, well, we got
Mhm.
plenty to do without that. That's, those people also specialize,
Mhm.
which is really important.
Mhm. That's good.
And are there certain things that you think don't need to have a cost segregation? Or do you suggest that to everyone to get a cost segregation analysis?
I don't know well enough.
Okay,
Yeah.
okay, just curious about that.
Mhm.
And then you talked about closing instructions.
Mhm.
You have when it's because you use the word complicated several times.
Mhm.
What makes a transaction complicated?
That's a separate statement in the closing instruction. I mean, what makes it, I mean, it's not always a dollar amount. I mean, it probably, I mean, if something has a high dollar volume, there might be, you know, might tend to make it more complicated, but not always. I mean, I mean, anything could make, I mean, if you figure that there are, you know, 400 provisions in a purchase agreement, I mean, what makes it complicated is that they may have a, you know, a complicated deposit, you know, scenario, or they might have environmental issues, or they might have, you know, inspection and cure issues. There might be many parties who have an interest. I mean, just about anything could make it complicated.
Sure.
I mean, I think, you know, the type of financing. I mean, generally, I mean, most of my representation, most of my practice has been for institutional, you know, for institutional parties, and there is, you know, the parties just tend to be like more sophisticated, and they're just, I don't know, there are a lot of parties, there are differing goals. I don't know, it's hard to say what makes it, it's really
Okay.
hard to say what makes a transaction complicated.
No, the first thing that ever comes to my mind is you've got somebody's passed away and now you've got 5 or 6 different beneficiaries, and how
Mhm.
complicated they can make it.
Yeah, yeah, it's interesting because I was just asked to help another law firm in a situation like that where it's a loan workout transaction, and all of there were multiple properties that were involved, and they were all held by one man. I guess nobody
Oh.
told them to form separate entities, and then that person died,
Ah.
and so there was just all this time spent splitting up each of the properties into, different LLCs. There were guarantee. So, and then they restructured the loan, and not all of the guarantors consented. And then we had to go back through the original loan documents to see if there were any errors, like make sure they had all the original notes. And so that's complicated. I mean, I guess one thing I can say is that loan workouts tend to be complicated. More complicated
Okay.
than an original loan transaction. But it's sort of hard to generalize about what makes something.
Sure, I understand that. Having gone through. Guy, by any chance, would you have any? You made a comment here about being in self-storage, but you have any curious questions to ask our wonderful Norma?
No, it was, really appreciate you sharing what you did. I'm in Iowa now, but I'm originally from California.
Oh, mhm.
And realizing that there are some statute items out there that do supersede maybe, or if it's not clarified inside the agreement. I will say that one of the things I do in all of my contracts, all of my purchase agreements, is that in order to avoid any type of earnest money loss, I put a whole section in there that says that you have to receive a specific approval from me on the due diligence.
Mhm.
Otherwise,
Mhm.
the deal, then the deal is canceled and the earnest money is returned.
Mhm.
So I do add that to that. So when I run into some state specific contracts, like in Texas, it's a little bit more complicated, because they all want to like line up on these state created documents. And so trying to get that workaround is sometimes a little bit difficult with a seller who only works with an attorney who's only familiar with state documents.
Mhm. Yeah, it's just really important to not assume that, a form, because it's a form and it looks complete and there are lots of words and someone else, and it must be okay. I mean, I was trained as a baby lawyer by the real estate partners. There is no such thing as boilerplate. There's just no such thing as boilerplate.
Right.
And a lot of people want to think that, but every single word in a document matters. And so, you don't go crazy with that, and you don't have to go excess, and you learn that certain things are certain places, but you just can't assume that a form serves your needs. You just can't.
Right.
So thank you very much for that. We're at the top of the hour. This has been wonderful. I learned a lot. Never occurred to me until I met you, Norma, to actually have someone look at a transaction that knew more than the broker. Yes. Like that. So thank you very much for coming. Hope you come back again sometime.
Okay.
All right.
Well, thank you. Thank you for having me. Bye-bye.